Swayam Prabha. Digital India. Educated India.
The seat of the Supreme Court is New Delhi. There have been some debate or controversy surrounding whether the seat of the Supreme Court can be beyond Delhi because litigants and lawyers have to practice and travel to Delhi very often. But right now, you will notice that post COVID, most of the court proceedings can be attended in a hybrid mode, both virtual as well as physical. So this has kind of eased the situation quite a bit. Of course, please note the process of appointment of judges could be that, especially in the high courts, usually judges are opted as additional judges initially for a year or two, and then they are made permanent judges. Uh, but that kind of an option is definitely in terms of trying to test the performance of someone and then making him a permanent judge of the high court. Because most of the judges of the Supreme Court come from the High Court, they are already having constitutional positions, so they become permanent member of the Supreme Court as well. But there can be situation where the president can appoint someone as the acting chief justice wherever the office of the chief justice goes vacant or is in temporary absentia. Then an acting chief justice can also be appointed by the president of India. Can there be an appointment of ad hoc judges if it is necessary for the discharge of the duties of the Supreme Court? Ad hoc judges can also be appointed, or even retired judges sometimes can be appointed if it is necessary for the case to be. Uh, Now, coming to the fact that the Supreme Court under Article 129 is a court of record, it means the Supreme Court is empowered to act as a court which can take cognizance of non-compliance of the judicial orders. And hence, we have what is known as the Contempt of Court Act, where either civil or criminal contempt can be initiated against any individual who does not comply or follow or adhere to the directions, orders, and judgments of the Supreme Court of India, which is, of course, declared as the law of the land by the Constitution itself. Now, if one evaluates all these powers of the court, one will say that the independence of the judiciary is something that the Constitution itself has prescribed, and it kind of lays down that the judiciary ought to be independent from the executive interference or from any kind of legislative role. However, if you see what is the reason why independence of the judiciary is a basic structure, why the independence of the judiciary is core and important to constitutional values and constitutionalism, and why it has contributed to the protection of democracy and fundamental rights of citizens, I think you will notice that the judiciary is one institution that is the most respected institution across the country. It is the judiciary that actually is the final door of justice, even for executive transfers and appointments or denial of any kind of privileges as well. It is the judiciary that actually lays down the fair grounds of every kind of governance. So I think wherever there is an encroachment of procedural or some kind of an interference by the executive branch, the judiciary has always kind of stopped it from touching its independence. I think what does independence of the judiciary do? First and the foremost, I think it brings about judgments that are not something that the judges have to fear or they need to favor someone. So that kind of fearless judiciary or a judiciary that is not arbitrary, unfair, or unreasonable seems to be the growth of establishment thanks to what the way independence of the judiciary has come into. So, impartial functioning of the judiciary is key to democratic and constitutional values. And safeguarding the tenets of justice is something that can only be done if the judiciary is independent. It is supremely secure in terms of its tenure, and is a court of records that can actually punish contempt of court even to anyone in the highest positions of government, be it president, prime minister, ministers, politicians, members of parliament, or members of legislative assembly, or even chief ministers for that matter. So, what have been the key, features of this kind of independence of judiciary? First and the foremost, of course, is the mode of appointment of judges to the court, which the judges have reserved for themselves. So, the role for the cabinet or the prime minister or the president is more a consultative process. It is not, so it is the judges who initiate the first nomination, and the government is involved in that consultative process. So you will notice that the executive's discretion in appointment is curtailed to a very large extent, and the kind of political influence on appointments is completely kind of taken off. So the politicians don't have a say. Their political ideologies cannot come into the scenario in terms of appointment of judges, and it's the judges who decide whether a person is suitable to occupy a position of a judge or not, because they are in that role, they are in that profession. So they are the best judge to find out the integrity and the independence of any judge to occupy such a high position. Second, apart from appointment, I think security of tenure to the judges is very, very core and important. As I told you, 65 years is for the Supreme Court judge. Very rarely in impeachment, actually, impeachment has never happened in India. Obviously, no judge can be removed from his position. Is something that actually gives security to the judges to act without fear or favor. So they continue to hold the office, though under the pleasure of the president. They are completely independent from even that kind of executive branch of the government. They have fixed service conditions. There is no problem regarding that. The parliament cannot amend the service conditions of the judges. They can amend it to their benefit, but not to their detriment. And please note, this kind of amendment cannot be done at any cost, except maybe when there is a financial emergency, but it has never been used so far. So the condition of the judges remains the same during the tenure of the office, or is enhanced from time to time as the pay scale fixation happens. All the expenses of the Supreme Court. Now, there are so many things that the Supreme Court is now doing. They have used a lot of digital technology to actually enhance the experiences in the courtroom and provide easy access to litigants and lawyers. There is so much of digitalization, there is so much of technology that is being used. People can actually access many things right now online in terms of listing of cases. Rather, the Supreme Court has also looked at how certain courts can become completely paperless. So can everything be uploaded and then the courts can decide? All of these expenses of the court is charged to the Consolidated Fund of India, and there is no vote in the parliament for the same. So which means the salaries, the allowances, the pension, and the expenses of administrative, wing of the Supreme Court are all charged to the Consolidated Fund of India, and this also ensures the independence of the judiciary. Uh, Interestingly, the conduct of judges cannot be discussed within the parliament or within the state legislature. This would amount to disrespect to the duties of the Supreme Court and the High Court judges. Uh, Please note, such a discussion of on the judges can only happen during impeachment and not under any other consideration. So that also ensures that the judges are not discussed either by the politicians or the executives. Uh, Please note, there is no ban after retirement. So once you leave the position of a judge, you can actually do so many other things. Right now, you will notice that some of the Supreme Court judges are taken as members of parliament. Some of the Supreme Court judges have been appointed as governors of a state. So there is nothing that prohibits them from continuing in some kind of in some kind of a position. A lot of judges act as arbitrators as well, and in some cases, a lot of high court judges have started practice as well. So that is how they are having what is known as post-retirement jobs as well. Power to punish for contempt is a very strong power, which I think clearly establishes that the judicial wisdom must be respected and honored, and no kind of challenge or some kind of deviation, which may lower the dignity and authority and honor of the court will ever be entertained. So I repeat, no kind of disobedience to the authority, dignity, and honor of the court will be entertained, and an action for contempt can also be initiated. What is interesting to note is that the Supreme Court has complete independence in appointing staff at the court itself. So they can appoint officers and servants to the Supreme Court without the interference of the executive, and they can also prescribe the terms and conditions for their service. Interestingly, the Parliament cannot curtail the jurisdiction of the Supreme Court. It can enhance, obviously. Again, that is something that is guaranteed in the Constitution, and the Parliament has no role in limiting the jurisdiction of the court. And finally, all of these have very clearly established that the judiciary is on its own. It's independent from the executive. The executive has very limited role in judicial functions, and hence judicial power possesses that kind of independence and authority in implementation of judicial administration in the country. Now, moving further, friends, let us look at the jurisdiction and the powers of the Supreme Court. Now, the Supreme Court of India has quite a few jurisdictions of its own, and the Constitution actually provides for such a kind of jurisdiction. And please note, the Supreme Court is supreme, and hence it can decide its own jurisdiction if the need be or if the need arises. But broadly, if the jurisdiction and the powers of the Supreme Court have to be classified, they can be classified into the following categories. First, we call as the original jurisdiction of the Supreme Court. So, original jurisdiction of the Supreme Court can arise in certain matters where you can go to the court directly as the first court to adjudicate the dispute. So, you don't have to go to the district court and the high court. You can go to Supreme Court directly. This is called the original jurisdiction. Now, original jurisdiction can arise between Government of India and one or more states. So, if there is a dispute between center and state, this is called the center-state relationship. Then you can go to the Supreme Court under original jurisdiction. Between Government of India or any state or states on the other side, or between one or more states, of course, this it is better to not go to the High Court but go to the Supreme Court. Article 32 also provides for original jurisdiction, because here is where a citizen's fundamental rights being violated. He can go to seek either habeas corpus, certiorari, mandamus prohibition as a writ remedy for the protection of his fundamental rights. As I told you earlier, Article 32 itself is a fundamental right, and that is where the original jurisdiction of the Supreme Court will arise. Of course, disputes arising from a treaty, agreement, covenant, or any other engagement or similar instrument can also come before the Supreme Court in its original jurisdiction. Generally, disputes between private citizens and the state and the center can also go. Most importantly, please note, any kind of interpretation of a federal law can also be part of an original jurisdiction that may arise between, that may go to the Supreme Court. Also, interstate water disputes are something that can go to the Supreme Court. Interstate water dispute is under Article 262. That can also be under original jurisdiction. Anything that is in relation to finance, center-state relationship includes finance, it includes taxation, it includes expenses to be adjusted between center and state. It can include some kind of recovery of damages from the state by the center, or any other ordinary commercial dispute or business-related dispute between center and state. All of these can go to the Supreme Court under its original jurisdiction. So I think the kind of challenges that federalism, what we call as the dual federalism that we follow, say state government and central government, all that can be referred to the Supreme Court. It is the apex court. It is the final word on the Constitution. It has the final word to interpret the principles of the Constitution, and hence the Supreme Court can take all of that into cognizance and decide under its original jurisdiction. Interestingly, under the original jurisdiction, also the Supreme Court can decide the validity of any law that is passed by the Parliament, whether it is constitutional or void. This kind of challenge can go to the Supreme Court. So any law that is passed by the Parliament can go to the Supreme Court directly under its original jurisdiction, and the Supreme Court can decide the validity or constitutionality, as we want to call it, of those legislations as well. Now, the Supreme Court is also a kind of a constitutional court of appeal. This is called the appellate jurisdiction, and please note, appellate jurisdiction is generally that is arising from the final decision of a high court. It can either be in civil or criminal cases. And please note, in most of these cases, it is the High Court that has to give a certificate saying that there is a legal question or a legal issue that has to be resolved through constitutional interpretation, and hence the High Court is referring the matter to the Supreme Court. So once a certificate of appeal is granted by the High Court, then the matter can come before the Supreme Court as an appeal for deciding a legal question, not based on any factual matter, and the same is provided under Article 132. So, what are the wide ranging appellate jurisdictions of the Supreme Court? Generally, you will notice it can be divided into following categories. First, appeals in all constitutional related matters that can definitely be arising. Appeal in civil matters, it could be anything about a law like land acquisition or so on and so forth. Appeal in criminal matters, for example, if a person or an accused has been given death penalty, he has a right to appeal to the Supreme Court, and that is an appeal in criminal matters. And finally, appeals that can be preferred as special leave petition. So these are, under Article 134, you will see criminal appeals. Now, criminal appeals, you will notice, is given to a person accused in a death row, or if the lower court, has sentenced him to death, then in all those cases, an appeal can definitely be preferred. So this is all provided in the articles of the Constitution, when and what can be the appellate jurisdiction as well. Yeah. So criminal matters, please note, certain things are quite interesting over here. Suppose the trial court has given, a kind of a sentence, and the High Court has reversed that kind of a sentence. In those cases, also certain kinds of appeal can be made. Yeah. Okay. Right. This is under Article 136, the appeal on special leave. Special leave is kind of an authority that is granted by the Supreme Court as a matter of its discretion, where it says that any judgment or any kind of an order that is made by a tribunal, it could be tribunals that have been established under various powers of various state and central legislations. Usually, tribunals are made under several laws. Today, you notice that most special laws have a tribunal in place: Consumer Forum, Right to Information, Competition Commission, Income Tax Tribunal. Then you can appeal to the Supreme Court even if there is no provision for appeal by taking the special leave of the court. And this is a very discretionary power. So where there is no appeal or right to appeal under any other provisions of the Constitution, the 136 appeal can be actually sought from the Supreme Court of India. See, this is not an ordinary appeal from the High Court, but it's mostly applicable to those that come from the tribunals. So please note, Article 136 special leave is a discretionary power. It cannot be claimed as a matter of right. It cannot be granted in any judgment, whether final or interlocutory. It may be related to constitutional matters, civil or criminal, or income tax, labor, revenue, or even matters of an advocate's right under the Advocates Act. So usually it can be granted against even High Court matters, but it's not necessarily so. But these are cases where the High Court does not give you certificate of appeal, and hence you are seeking the special leave of the Supreme Court of India. So under Article 136, friends, please note, it is a very, very wide power. So wherever the High Courts are not granting this certificate of appeal, wherever the tribunal, from a judgment of a tribunal, you have no right to appeal, then the Supreme Court still has the power to grant you special leave and saying, please come before us, we will decide and give you justice or give you the finality of what the law should be. So this is highly an exceptional power that is granted, and you would notice that this is a power in which you can override all other lower courts decisions. So it's like saying, if the High Court does not give you a certificate of appeal, what do? You have no other choice. So let the Supreme Court decide whether this is a good case to come to the Supreme Court or not. So I think those are the reasons why this provision in the constitution is there. So that's why we say it's the apex court, it's the final court to decide whether matters should be in one way or the other. Okay, so again, I must say that this is an extraordinary situation where 136 appeals are being allowed, but this does give unfettered powers to the Supreme Court to set down what shall be the rule of law in case of judicial appeals. Article 137, the Supreme Court has power to review any judgment or order made under by any other law made by the Parliament, or any rules that are made by the Parliament as well. There is something called the writ jurisdiction of the Supreme Court as well. As I told you, writ means writ petition under Article 32 for the violation of fundamental rights. That is called the writ jurisdiction. And the Constitution has provided the writ jurisdiction to the High Courts as well. And we have already discussed when such writ petitions or writ jurisdictions come into play. You have, Article 138 and Article 141. These are also those articles that give power to the Supreme Court. As I've already told you, deciding parliamentary laws, whether they fulfill the mandate of the Constitution or whether they're constitutional or not, is something that the courts can make a final call upon. Now, coming to Article 142, the Supreme Court has power to pass any decree or order necessary to ensure complete justice in any pending case, or pass such decree that is to be made enforceable to the entire territory of India in a manner that may be prescribed by the Parliament or by the President. So, what the Supreme Court has here is the power to issue orders for securing even the attendance of a person, discovery or production of documents, or investigation or punishment of contempt for the entire territory. So 142 very clearly says that the power of the court is extended to the entire territory of India, right? So please note, though the Supreme Court is not a trial court, it is not a court of evidence, yet if the Supreme Court insists that they would want to summon someone, they want to examine any document or any kind of evidence, then the Supreme Court still has the power to continue doing the same. Coming to the next jurisdiction of the Supreme Court, it is called the advisory jurisdiction of the Supreme Court under Article 143. There are two categories in which the Supreme Court can give an advisory opinion. First is on any question of law or fact of public importance which has arisen or which is likely to arise, or any dispute arising out of a pre-constitutional treaty or agreement, covenant, or etc. So here, to exercise advisory jurisdiction, please note, being the highest court, I think the President may want to seek the advice of the Supreme Court. So the President can refer any such question to the Supreme Court, and the Supreme Court is duty bound to provide this advice to the President of India. Usually, such kind of an advisory opinion is given to the government whenever there is there is a kind of a problem in understanding a judicial verdict or the judicial order, and there are more than one interpretation that is possible. That those are the circumstances when the government would want the Supreme Court to give an advisory opinion. So please note, it is not a judicial pronouncement. It is only an advisory, but it is something that is sought by the President. And please note, once the advice is given, it's not necessarily that the President is bound by the advice. He may just follow the opinion in the advice, or prefer not to follow that opinion in the advice. So this kind of facilitates the government taking an authoritative legal opinion from the Supreme Court, apart from probably seeking the same from, say, the Attorney General of India, who is the first law officer, or the Solicitor General of India. So still the Supreme Court can come as in an advisory position. So generally, advisory opinion of the Supreme Court has been asked in many matters. I can give you the list of some of these acts or legislations in which the advisory opinion of the court has been sought. Let us take some of them. The latest one, if I recollect, is the 2G spectrum case, where auction was mandated by the court, saying that auction is the rule and first come first serve should not be followed. That was the case in terms of whether auction is a rule for all natural resources, and second, is the auction the only rule, or should it be the preferred mode? Because in some cases you may not want to follow auction. So that was something that the President sought after a judgment of the court. So on an advisory jurisdiction, the Supreme Court did clarify and say auction is not the rule, it is the most preferred mode. So that is how clarificatory opinions are sought to probably a judgment of the court, so that there is clarity in the implementation. So the executive may want to seek that clarification as the case may be. Ram Janma Bhoomi case of 1993 is another case in which advisory opinion was sought. Um, the Delhi Law Act of 1951, the Beruberi Union case, Sea Customs Act of 1963, Keshav Singh's case, President's Election case, Special Courts Bill of 1978, Jammu and Kashmir Resettlement Act, Kaveri Water Dispute Tribunal 1992. All of these have been some of the cases in which the advisory opinion of the Supreme Court was sought.